Hello and welcome to the semester's first event of the Duke program in public law. I'm Tom Rowe on the faculty. Many of you haven't seen me because I was visiting away last semester at UCLA, but I'm very glad to be back and am pinch hitting for Chris Schrader, the chair of the program, who is in class and will be here at about 12:30. It's my pleasure to introduce a distinguished graduate of this school, Kenneth Starr. You probably have heard of him. During his career at Duke, he was in a small section taught by Professor Walter Dellinger, which also included others that you may know or know of. Some of you maybe had classes from Len Simon last spring, and also he was in a small section with Dan Blue, the former Speaker of the North Carolina House of Representatives, and they are going to be co-chairs of the Class of '73 reunion. He was also a classmate of our former Dean Pamela Gann, who is now president of Claremont McKenna College in California. And he also served during his time at Duke as a notes and comments article of the Duke Law Journal. Then he's had a very distinguished and varied career in private practice and public service. He has served in the early 80s as counselor to Attorney General William French Smith, and then became a member of the U.S. Court of Appeals for the District of Columbia Circuit, followed by service during the administration of George H.W. Bush as Solicitor General of the United States. And his later public service, for which he was named Co-Person of the Year by Time Magazine, with someone else of whom you may have heard around that time, he served as independent counsel to end all independent counsel. And he is now in private practice in Washington, and then let me just mention a couple of things about the programming. This is also being webcast, and I understand that the table mics are live, so during the question and answer period, you may need to be careful of not bumping into them and so forth to create excess noise. After the talk and the question and answer period, Ken will be down in the Blue Lounge to sign copies of the new book that he is here talking about on the Rehnquist Court, for those of you who have copies or would like to buy copies and would like to have them signed by the author. I think without further ado that it's time for me to welcome back Judge General Starr.
Thank you. Thanks, Tom. That was great. Thank you very much. Thank you. Well, it's wonderful to be back here where Alice, my bride of 32 and a half years, really began our married life. And the law school has remained so very special to me. I've been privileged to remain involved in a number of activities and maintain friendships over the years. And to come before you and to talk a bit about constitutional law in this venue reminds me that my constitutional law professor was William Van Alstyne. And now he's still very youthful. I've aged, he hasn't. But I'll tell you one thing, I still find it difficult to understand Bill. I really have to worry. He is so smart, and so after when we were getting into ripeness and justiciability, I'd had a couple of years out of law school. I'd gone to graduate school. I'd made fairly good grades along the way. I said, I do not have a clue about what he's talking about. This is really scary. I'm paying tuition and so forth, and I can't go to medical school. I really thought that maybe that career at J.C. Penney was going to be my career after all. But all's well that ends well, to coin a phrase. It's great to be back, and with Professor Rowe, Professor Schroeder, the dean is not here, but I'm occupying her office in a very peaceful sense, and it's wonderful to be back home. What I thought I would do to get the ball rolling and really just to anticipate your questions and comments, which will be much more interesting for me and I think much more enjoyable for you, is to share with you just a couple of very quick stories that provide a backdrop for the book and the idea for the book. The first is the flag burning drama from years ago, which was so very controversial at the time and has now sort of receded into history. Feelings are much calmer about the issue now than they were over 10 years ago when the issue first arose. And the second, also related to the First Amendment, is in the Establishment Clause area, and that is the Bridget Mergen story on the Equal Access Act. Those are the two stories I will tell very briefly, and I'm going to try to tell them in a way that I hope resonates with what Akhil Amar at the Yale Law School tries to achieve with his students, and that is that it's quite important not only to develop the skills in the law, but also to have an appreciation for lives in the law, including the lives of those clients or those actors on stage that gave rise to the legal controversy. And Akhil, as you know, Tom, from your friendship with Akhil, actually has an occasional program that he simply calls Lives in the Law, sort of inspired by the Holmesian admonition about experience and how important experience is. So these two experiences, I'll keep an eye on the clock so that we have lots of time for questions and comments. And organizers, am I at liberty to kind of walk around? I mic to walk around. Does that foul up webcasting? Hearing no objection. Good. I don't like standing behind a podium. The first is flag burning, and I want to begin with a basic fact. Probably all of you know that basic fact, namely that in the case of Texas versus Johnson, the Supreme Court of the United States, by a 5-4 vote, struck down the Texas flag anti-desecration statute as a violation of the First Amendment, our system of free expression. The reaction was extremely intense. And at the time we were taking office, I was leaving the court and coming back to the Justice Department where I had previously served, and one of the many issues that we had before us is what to do in light of the unfolding debate over the issue of the protection of the flag. The president felt strongly, as a member of the greatest generation, you know the story, he was shot down, he saw combat, he felt very strongly about the issue of the protection of the physical integrity of the flag. And so did, this is, you say, oh well, just a bunch of Republicans. No, it was very avidly bipartisan. With the chairman of the Senate Judiciary Committee, Senator Biden, presiding over the hearings, and very thoughtful conversations about how to protect the flag. And so that was just sort of, we want to protect the flag, how do we do it? My colleague at the time in the Justice Department, and who went on to become the Attorney General of the United States, Bill Barr, was then serving as the head of the Office of Legal Counsel, where your own Professor Dellinger and Professor Schroeder were destined to serve under President Clinton, before obviously Professor Dellinger went on to serve as Solicitor General. It was the considered view of those experts in the Office of Legal Counsel who took a very careful look at this, that it would in fact require a constitutional amendment in order, unless someone changed his or her vote, in order to pass constitutional muster with the Supreme Court's interpretation of the First Amendment in Texas against Johnson. There were very thoughtful observers who said, no, I think that one can have a content-neutral flag protection statute, among others, Professor Rowe, Professor Tribe at the Harvard Law School so testified. So everyone went back and forth on this, and Congress saw fit, in the fullness of time, to pass the Flag Protection Act of 1989. It was very promptly struck down by two district courts. Congress provided for expedited review to the Supreme Court of the United States. It fell, of course, to the United States to defend the constitutionality of the statute. So I want to use that as a little bit of a bookmark, because one thing I would love for you to take away from these reflections together is here's an example of this conversation that has gone on at the political and constitutional level, constitutional dialogue between the executive branch and the legislative branch. So here are the Article 1 and Article 2 branches conversing with one another, and the official position of the Article II branch was you need a constitutional amendment. Congress worked its will, and I should note that President George H.W. Bush, I just call him President Bush the 41st, to be simple, not George the 1st. President Bush the 41st signed the Flag Protection Act into law, but did note in the signing statement that there were serious constitutional issues in light of the breadth of the court's opinion in Texas versus Johnson. It falls to the Solicitor General to defend the statutes passed by Congress with a couple of exceptions that maybe we can go into in the question and answer period. And so it fell to me we viewed that as what we call in the office an SG case. This is the kind of case that should be argued by the SG and not by one of the very able other 18 lawyers who serve in that very small and special office of Solicitor General. So I was in the process, the briefing was on an expedited basis, and it just so happened coincidentally that I was appearing at a moot court at the University of Illinois Law School. So I'm SG, every now and then go out to a law school. And there were two other members of the moot court. The presiding member of this court was Justice Antonin Scalia. And Justice Scalia had been in the majority in Texas versus Johnson. So one of the issues is, where do we get that fifth vote? Texas versus Johnson was 5-4. We need to pull off one vote. Justice Brennan used to say this. Remember this? It was part of the folklore around the court, I'm sure, when you clerked for Justice Stewart. Remember the great rule in constitutional law, the rule of 5. You've got to have 5 votes, and with 5 votes you can, quote, do anything. Now, it bothers me a little bit anyway. That's just part of the realpolitik of life in the Supreme Court. So here we are in beautiful Champaign, Illinois, and I'm about 3 weeks away from the argument. And we have a student forum like this, and Justice Antonin Scalia then says, words to this effect, "I never slept so well as the night that I voted in Texas versus Johnson. I hate that guy. I love this country. I love the flag, but I knew as a judge," and so he gives a speech. I'm sitting there, this is not good. I'm down 1 already. I don't think he's going to flip. In the fullness of time, the case was argued. Justice Scalia was all over my case, and the court was exactly where it was in Texas versus Johnson. And in the case, it's there in the law books. It's available. You can pull it up online as United States versus Eichmann. For those of you who know your history, there's a very evil man called Adolf Eichmann. And one of our wags in the office said, "Starr, all you have to do is stand up there in the Supreme Court and just say, 'This case is United States versus Eichmann. We win.'" So, well, it didn't work out that way. Well, I lost 5-4. The Supreme Court of the United States determined that flag burning was a form of expression, part of our system of free expression, and protected under the First Amendment. I wanted to share with you a few stories about the argument, but time causes me to say that was really one of those epiphanies when I said that in light of the way the argument unfolded and how strongly the American people felt about the issue, and not just members of the greatest generation. By the way, John Paul Stevens was in dissent in both cases. He's a member of the greatest generation too. Chief Justice Rehnquist was in dissent in both cases. He's a member of the great. You know what I'm talking about, the greatest generation, right? World War II. I mean, if you served in World War II, Saving Private Ryan just kind of gives us an idea. If you served in combat, as those 3 folks did, the intensity, the emotion is just so powerful, and obviously we want judges and justices to do their very best to set aside emotion and to try to be guided to the fullest extent possible by the principles of the law. And I'm not suggesting that they weren't. I think reasonable minds could differ with respect to the protection of the statute. But I felt that the American people would have benefited by having seen the argument, and would have benefited had there been a culture in this country, in the information age, to actually read the opinions of the Supreme Court of the United States. It would have been educational. And for those who felt very strongly that Congress was right and the court was wrong, that Texas was right, the court was wrong, it would have been useful. And that was my epiphany. It was part of the epiphany, I should say, but it was a pivotal part, that when I left the office, I wanted to write a book that would make the court, in a very substantive way, much more accessible to the entire nation. Obviously, not even people who are lawyers practicing law follow, they just can't, assiduously, the work of the court, the development of doctrine, and the like. But the idea was more broadly, and I chose not to go with a university press, and I did have that opportunity, but I wanted to go with a trade press that would actually then get this on the shelves at a Barnes & Noble and the like, and it's difficult with the university press having that kind of distribution system. Story number one. Now story number two. The Bridget Mergens case. This was also part of this epiphany. It wasn't quite as dramatic as flag burning, and the feelings didn't run nearly so high, and I had nothing as dramatic as my University of Illinois moot court experience. But very briefly, as part of the struggle doctrinally with the Establishment Clause, and what does the Establishment Clause mean? Congress shall make no law respecting an establishment of religion and then applied to the states through the 14th Amendment. What does that mean? And obviously the court has struggled mightily doctrinally, and maybe we can talk about that. But in this particular episode, and now I want to talk about the conversation that occurs between Congress and the courts more generally. In a series of opinions in the early 1980s, including a very important Fifth Circuit opinion called ACLU versus the Lubbock chapter of the ACLU versus a particular school district, the Lubbock School District. The Fifth Circuit determined that it violated the Establishment Clause for there to be in public schools receiving federal financial assistance, but in public schools, they happen to be receiving federal financial assistance, to allow Bible study clubs, prayer groups, and the like to meet on campus. The idea was separation of church and state. And there were several such opinions, and at the time, politically, the controversy over school prayer, should there be a voluntary school prayer amendment to the Constitution, was likewise swirling, and that was part of the context within which this debate took place. Congress, and again, just as in the Flag Protection Act of 1989, responded overwhelmingly in a bipartisan fashion with the Equal Access Act of 1984. Congress held hearings. Why are the courts holding this? This seems inimical to the idea of a free society, that students voluntarily can't have a religious club, a Christian club, or whatever the religious group might be. This happened to be Christian groups in these cases that gave rise to the issue, but it could have been any religious group, when other groups are permitted to meet on campus. And hearings were held, and various professors testified, and while no judges testified, there were also academics explaining, here is the principle that's causing the judges to do that. Congress responded with an overwhelming majority passage of the Equal Access Act, which simply said, if you, obviously I'm paraphrasing, if you, school district that receives federal financial assistance, allows one or more defined extracurricular groups to meet on campus, then you must allow all sort of kink or educational disruption exception built in, you must allow all groups to meet on a non-discriminatory basis, and thus the term equal access. There was considerable focusing on the triggering standard. What should trigger the operation of the statute? Obviously, any federal financial assistance, and I think virtually all, if not every single public school district in the United States receives some form of federal financial assistance. But that's not the trigger. What's the trigger? The trigger is the clubs. So there was discussion and colloquy in Congress, well, should we allow sort of a de minimis exception, maybe 5 clubs? And they had testimony. I mean, what does it look like? Let's take a snapshot of what large high schools, or maybe even not so large high schools, look like. Let's look at their demographics and see what the extracurricular activities, and not surprisingly, they found that some schools had a very few extracurricular clubs, and many of them were started in an entrepreneurial way, reflecting the interests of the students at that student body. Sometimes it would be a faculty saying, let's have the French club and the like, but not infrequently, these activities reflected, and think about your own school experience. Right, we were kind of encouraged at my public high school. If you thought, let's have a group that is focusing on fill in the blank, that's terrific. You want to have a faculty sponsor, etc. Anyway, that's the backdrop. Senator Patrick Leahy, to show you the bipartisan nature of this, felt very strongly and took the lead in making sure that the triggering mechanism was one or more. If there was one or more, but only one extracurricular group, then you had to allow these groups, religious groups, Bible study clubs, and so forth, to meet. So there was the dialogue, essentially an overruling of an interpretation by, you start thinking, hey, we've talked about this, City of Bernie versus Flores, and a whole rich group of cases. Wait a second, is Congress interpreting? Well, no, wait, they're not overruling. This isn't like RFRA. They're not purporting to overrule doctrine. They're just saying, if you want federal financial assistance, South Dakota versus Dole, here's what you're going to have to take. Well, sure enough, the constitutionality of the Equal Access Act was drawn into question in litigation. In the fullness of time, I was called upon to argue that case, and the Supreme Court decided that in favor of its constitutionality, really 9-0. Justice Stevens wrote a concurring opinion just questioning whether Congress meant, a statutory interpretation, an Ashwander kind of opinion, but the court was unanimous in saying that the act is in fact constitutional, not running afoul of the Establishment Clause. I felt then, based on that experience, that again, there was this lacuna, this gap in public understanding, and even at very sophisticated levels, including, and this is what, as I was getting into the case, what really surprised me, the interpretation that was being embraced by various very learned counsel to school boards around the country in terms of what the Establishment Clause provided, including whether the Equal Access Act passed by an overwhelming majority of Congress was constitutional or not. We had so moved in the direction of separation and non-accommodation Establishment Clause doctrine, and you see that in various areas of the jurisprudence, that even with Congress having spoken by this overwhelming bipartisan majority, with just very few voices raised against it, that it's still unconstitutional, and we're going to pay money to challenge its constitutionality. And the case that actually went up was that involving Bridget Mergens from Omaha, Nebraska. And she went to a large suburban public high school outside Omaha, Nebraska. And the Board of Education said, I'm sorry, you cannot have this Bible study club, which was going to be open to anyone who wanted to. So, it's you don't have to have church membership or anything else. It's open to anyone who obviously will be self-selected, presumably, but anyone can come in. Whether they are believers, non-believers, active, non-active, you are welcome here. We do not exclude anyone from participating in our clubs. There's a non-discrimination principle as well. That process confirmed what flag burning had shown me not too very long before, which is these are issues that the American people so care about. Yes, we care about war and peace, and we'll argue about Iraq, or at the time the Persian Gulf War, or we'll argue a generation ago about Vietnam and so forth. And exactly right. But one of the things that people tend to argue about over the dinner table, or at least in some form, even within families, are issues like abortion, school prayer, affirmative action, those social issues that really affect us all. And so I wanted to make these as accessible as possible to the American people. And that was the idea of First Among Equals, the Supreme Court in American Life. And perhaps with those two stories, Professor Rowan, I know you need to go. we can open it up or proceed however you would like.
Looks like you have
Okay,
question.
good. Yes, sir.
In light of your goal of promoting understanding of the role of the Supreme Court in American life, what are your opinions on possibly easing media restrictions in the Supreme Court, maybe even allowing cameras in the Supreme Court?
I think they're long overdue. I'm entirely in favor of cameras in the courtroom. I think it's going to take a fair amount, though, of public expression of interest, which we saw during Bush versus Gore. And we saw how riveted the nation, and really a lot of the world, became during Bush v. Gore, and listened to the oral argument after the fact. And that those evenings, I don't know whether you had this experience, but I was riveted to the television set, even though I'd listened to a fair amount of, through just sort of media streaming, so listening over a laptop. But that evening, I tuned in cable, and I loved it. I think I was watching MSNBC, but I think it was on, when a justice would be asking a question, they would put his or her photograph up on the screen. Now, I said, hey, that's really neat. That's terrific, because you're hearing, Justice Souter or Justice Scalia, Justice Ginsburg ask a question, and there is a photograph that makes this process human. And if people, and I know people, I'm quite realistic. I know people viewed the whole thing through partisan lenses. I'm in favor of Vice President Gore, therefore the Supreme Court is all out to lunch. I'm in favor of Governor Bush, and therefore the Supreme Court is a bunch of geniuses, except for the two people who were in dissent. Brave geniuses at that. I understand that. But for those who were more sort of, okay, I've got my feelings, but I also want to, instead of just announcing the way I feel and how strongly I feel about it, let me try to learn a little bit more about this. I thought it was terrific. And I think it's a harbinger of things to come. It seems to be generational, because Justice Souter testified on the budget when asked this question, sort of said, over my dead body. Well, I guess he has to leave the court unless he is outvoted. The sense I get is that a few of the justices are sympathetic, but the majority are just sat against it. And I think that's really unfortunate. Yes.
I have two questions that are sort of related. In your book, you mentioned how the world would be much different if Reagan would have paid attention to ideological versus gender concerns in
Right.
1981 in nominating O'Connor versus Robert Bork. So my first question is, do you think that those are good concerns to have, and do you think that was the right decision? And my second question is, given that all of us would love to have a Duke Law alum on the High Court,
I'd place my money on Walter right now.
Are there any decisions in your career that you regret, in the sense that at one point perhaps you would have been, put up to the level of a
Right.
Supreme Court justice?
Well, I am told that, and I have no reason to believe this, that I was, quote, a finalist for under consideration when I was SG for the seat that Justice Souter holds. But I'm very clear-headed in terms of how controversial the whole, especially the Lewinsky phase of what my family and I, we just call it the recent unpleasantness. And so, to coin a phrase, I've sort of moved on. And in fact, I think it was difficult even at the time for the appointing authority to consider, to go ahead, even though there was support for Ken, and we like Ken, he's a nice guy, and so forth. And he means no harm, so to go on the court. But, I'd taken controversial positions even then. Roe v. Wade was wrongly decided and should be overruled. That's pretty controversial. So to what extent is the appointing or nominating authority willing to go in that direction? That's always an issue. To go back to your first question, in terms of 81, it certainly was the right decision from Ronald Reagan, and I came to know President Reagan better because he's in this terrible disease has him now, of Alzheimer's. But I came to know him better after he left the presidency. Just there is no, whether you hate him or love him, there is no guile in this man. He is completely guileless. He is just so honest, and And so anyway, the Young Turks at the department, and I was, I guess, one of those, looked very carefully at what then candidate Reagan had said in the 80 campaign, and we were satisfied on the two occasions that he spoke to his aspiration to a point where he elected the first woman to the court, that they were aspirational expressions of goals as opposed to a moral commitment. And so the Attorney General discussed this with the President, and I don't mean to suggest any criticism of any of his successors, but Ronald Reagan didn't parse words. I mean, he was never trained in the law, so maybe he just, but it just wasn't the way it was. He said, what he meant to say is, I intend to appoint a woman, and I'm not going to try to get out of that, even though at that time, in contrast to now, I mean, it's 22 years later, the pool, the reservoir, happily, of women highly qualified to serve on the Supreme Court, and now look, Ruth Bader Ginsburg followed in the shoes of Sandra Day O'Connor, and there are many. Well, Chief Judge Danelle Taha should be talked about for a Bush appointment. Wonderful judge. She's the chief judge of the 10th Circuit. A terrific record, thoughtful, and so forth. I could keep going. There are lots of women now, but remember the story of Lazy Bee of Justice Sandra Day O'Connor, Stanford Law Review, and she couldn't get a job. And she was actually offered a job by a major law firm as a legal secretary. I mean, that's how bad it was for your parents, or at least certainly grandparents' generation when they were leaving. So how? And I think Ronald Reagan sensed that it was time, and so it was the right decision for him. That was more important to him to be a person of his word than it was to listen to the legal beagles that, this seat, this is Potter Stewart, and we've analyzed. You can criticize that, but he knew what he wanted, and he was just determined that I want the first woman to go on the court. We're overdue. We're a couple of centuries late. Yes, in the back.
Yes, I would be interested in your thoughts about the University of Michigan affirmative action cases and what role Justice O'Connor might play in that.
Yes. Well, great question. Let me begin by saying that one of the points I try to make in the book is that this is a don't rock the boat court. I use various examples of that. It's not that they never overrule. I could cite many examples that they do overrule their own precedents. But quite dramatically, as we saw recently in the Miranda context and the Dickerson case, which I talk about, I devote a book to Miranda because I think that is a useful way of understanding the current court as against the court of Earl Warren and how the court has changed in various ways. But when push came to shove, the court stayed the course 7-2 that Miranda was a constitutional decision. I wasn't surprised by that, even though a number of people I knew were somewhat disheartened because as a matter of principle, Miranda warnings may make a lot of sense as a matter of policy, but the jurisprudential strength of Miranda as a judge-imposed rule throughout the Federal Republic was, in my judgment, tenuous. Anyway, I think that makes the point. It is a court that tends to stay the course. Now, what does that mean? In this context, Bakke obviously looms very large, but only Justice Powell really addressed specifically diversity as a compelling rationale. Under Marks versus United States, we view Powell's opinion as controlling, and it has tended to be followed, but it's a different kind of precedent. So I think that's quite intriguing. How Justice O'Connor and perhaps Justice Kennedy would deal with Bakke and the Powell precedent. Huge issue. But secondly, I believe that the court will stay the course in saying strict scrutiny applies. That's been the course that they've been on since Croson in 1989, I believe it was. So a full decade after Bakke, greater rigor is brought back into this area through the Croson, and the Croson line has continued uninterruptedly, save for Metro Broadcasting, and then speaking again through Justice O'Connor, the court returned to the strict scrutiny framework. All right. In light of that, I'm not a wagering person, but I would say I think that a majority, maybe a 5-person majority, will be disinclined to conclude that diversity is not. I've got too many double negatives. I think 5 justices will be willing to accept diversity as a compelling rationale in the context of higher education. I further believe that the battleground will be on narrow tailoring. And there, I think there are going to be some very, and I don't know the record. I intend to learn the record in the coming weeks, but I've been otherwise engaged in a few other activities. But I need to study the record a bit more to really look at the narrow tailoring issue. Are there other ways of accomplishing that compelling interest as opposed to the way Michigan promotes? So I would say keep your eye out on narrow tailoring.
Thank you.
Any other? Yes, sir.
I guess kind of following on that, the affirmative action debate being a very political debate and one that is going to be discussed in the courts, I wonder, basically, what do you think that the American public ought to be doing with this information and understanding of the court, if it's even possible? I mean, what changes do you think?
Well, good point. You know, I really do idealistically believe in the fundamental value of education and having an informed citizenry for its own good, even though you don't then go out and elect that person at the next election round. I do think it would obviously enhance, as the Bork hearings did, public understanding of various aspects of our constitutional framework. So I cannot point to a specific instrumentalist value to be served by a more informed citizenry. It just seems to me, frankly, somewhat unfortunate, I won't say tragic, but it's certainly somewhat unfortunate for these kinds of issues. Say Boy Scouts. Boy Scouts is such a lively issue. Boy Scouts, and the issues not to be understood as opposed to just in a results-oriented, you know, I think gays should be, but this is terrible, or I think there should be freedom of association, or, you know, whatever the reason might be to be pro the Boy Scouts position. And what I encourage people, especially, I'm very involved in our church and we do a variety of things, I encourage people, look, instead of just saying, I like this or I don't like that, be more intelligent, be more reasoned, start reading some of these cases. You don't have to go to law school to be fairly learned in the law. I mean, you have commentators who never set foot in a law school other than to speak, but who never enrolled in law school, who love to opine on what the courts do generally and what the Supreme Court does specifically. You know, a lot of commentators do that on the left and the right. Well, if that's so and the popular audience is reading that, why don't they have more of an attitude of, Hugo Black's idea, I want the opinions to be written in such a way that they can be read by, everybody. If you're literate, you should be able to read it. Now, certain obvious information avenues are there. The information is now so accessible. So that's not the problem. It rather is a cultural shift that this is not an area, constitutional law, that should be viewed as the precinct of lawyers and judges and law professors. Yes, it's part of their precinct. That's what they do. But it affects us all, and so we should have a richer understanding of it. And frankly, I think it's easier to understand these issues than it is Social Security, quote, reform. I find that stuff really hard, and I read stuff, prescription drug, what's the right program? I mean, I'm more of a private markets kind of guy, but that's a predilection as opposed to a careful study. I think that the average, certainly college graduate, but I would hope even a high school graduate, could understand the issues in Boy Scouts or Roe v. Wade and so forth, would actually read enough if they had, time and interest. And that's what I think I would like to go. I had another epiphany. May I share another epiphany? He said, this guy's got a lot of, he's got a breakout of epiphanies. I went on a U.S., not AID, what group? USIA, thank you. A USIA trip with 2 political scientists when I was serving as Solicitor General down to Chile. Chile had recently restored democracy, etc., was the theory, and so we go down there. And we're debating the issue of separation of powers. And we weren't trying to proselytize, we were just hear the issues and so forth and so on. Well, this was my one and only trip to Chile. We were in Santiago, Valparaiso, and so forth. And I was really amazed. In Chilean culture, I saw it with my own eyes. You can buy the legal codes on the streets. And I said, this is fascinating. Are those just lawyers going, buying these little, books with, the employment code? I mean, it's a code, obviously it's a civil law country. Buying the code. No. We all have our codes, and so just as, Starr quaintly carries around his Constitution, a worker, I was told, I'm not reporting, this is what was reported, will have his or her copy of the employment code, and instead of just going to, the shop foreman or something yourself, you deal with, or your union representative, you deal with the person yourself. You say, hey, here is the issue, and this is my reading of the code. And I said, well, that's kind of neat. Most Americans have never read any part of the Constitution. I mean, it's really, we say, we love our Constitution. Isn't it odd that we've never read it, studied it, and then the perfection of the Constitution, understanding? I volunteer through our church. I'm involved extensively in the inner city in Washington. And in volunteering at Anacostia Senior High School, I was shocked when we're talking about equal protection between Brown versus Board of Education. These are high school seniors, that they really had not had much background in the history of the framing, the proposing of the amendments, the great post-Civil War amendments ratified in 1868. Okay, well, let's go ahead. Let's do a little Civil War background. Pretty uninformed. They knew that they were pretty uninformed about that, other than just in the broadest. Nobody had heard of Fort Sumter, and you can say that's an irrelevant fact. That's not the way we teach history anymore. Star, you're in the past. But I just found it odd that you didn't even know that there is such a thing called Fort Sumter and what was happening and leading up to the decline. But then what really surprised me was that they were totally unaware of Lincoln's second inaugural, 6 weeks address, 6 weeks before his assassination, carved in stone at the Lincoln. I could keep going. And I learned, by the way, that at least at this particular high school, there is no American history taught prior to the 20th century. Well, then someone wants to talk about cultural illiteracy. I mean, my word, how can we, Dr. Franklin, a republic, madam, if you can, yes, it was an imperfect republic because of slavery, but it was perfected by, at least structurally perfected, by the shedding of blood in the Civil War, Lincoln's determination, and then the post-Civil War amendments. For us not to appreciate that gets me really concerned. Now, what will be the result, who knows, but we will be certainly a more informed group of citizenry, and I think that bodes well for the Republic, but I can't give you a scientific study to demonstrate that. Yes, sir?
I believe Justice Thomas just signed $1 million book deal for his memoirs. I read, and I was just wondering if you thought that was a good thing and made it more accessible to personalities of the court, or if you saw that as kind of tarnishing the image and maybe a cashing in quality to it.
Boy, I'd love to cash in. When I saw that, I said, boy, this is a free society and so forth. I think the number sort of jumps out at one. It's a very high number. On the other hand, he writes in a tradition of Supreme Court justices who have seen fit to write, some quite famously, and provocatively. Justice William O. Douglas, quite famous for his writings. And obviously the Chief Justice of the United States has written charmingly and more narrowly on various subjects. And then Justice O'Connor. I mean, Justice O'Connor's been out pushing her book. I think proceeds may go to charity or what that I don't know, and it doesn't matter. But I mean, she authored The Lazy Bee because it was her story. That she and her brother had this wonderful story to tell about, life on the ranch in Arizona. And she went with a commercial house. So I just say, if people criticize them, they better start rolling back and saying, and Justice O'Connor shouldn't do this and the like. I happen to think it's great for the justices to be talking about their lives, their personal experiences, and so forth. And if books are a way to do it, that's great as long as it doesn't compete with mine. Yes, sir.
2 quick questions. One about the separation of, I guess in your career, of your own political views from viewing the law. I know people had, criticized you during the whole recent unpleasantness with,
There was criticism?
you know, of your,
Gosh.
you know, of your religious zeal, you know, and your politics, you know, shaping your view of
Right.
the law as opposed to
Right.
the law itself. And I was
Right.
wondering how you dealt with that.
Yeah.
And-
Well, I do think, I certainly think, especially in the Justice Department, Professor Schroeder is now here, and he served there. One of the things the Justice Department really does pride itself on is honestly and fairly enforcing the law. The law is the law is the law. And so there's a certain Herb Wexler, I call it Platonic attitude that here's the law, and unless the law, let me just go ahead and put this bookmark there as well, intrudes into the power and prerogative of the President of the United States, and therefore we will say we're not going to defend it and the like. But with that exception, or the so-called red-faced test or this straight-faced test, you just cannot defend the statute, which is extraordinarily rare. It does happen. It does happen. But your job is to defend the law. That's part of the faithful execution of the laws. And that's certainly the way or the culture that I tried to create within our own little group in the Justice Department, and at Duke, as a matter of fact. Dean, again, was kind enough to give me the opportunity before all the indictments started coming down at the Arkansas phase of the investigation to kind of set forth, a platform for setting forth sort of my vision, moral vision and professional vision of the office. And I described at commencement in 1995, shortly before the first indictments came down, of Jim Guy Tucker and James and Susan McDougal, and then there have been some guilty pleas along the way. Now what I was trying to create was a microcosm of the Justice Department. And therefore I brought in to assist me career prosecutors, two of whom had won the John Marshall Award for outstanding trial advocacy. One had received that award from Attorney General Janet Reno. I tried to get people from U.S. Attorney's offices. I had two corruption chiefs, one from Los Angeles, one from Miami, join us. I had one of the most experienced fraud prosecutors on the Whitewater phase, in charge of the Whitewater phase of the day-to-day investigations and trying to unravel what had happened and so forth. So, but what I found about the end, now to bring this back to something that's more enduring, because the last thing you need to hear is some apologia from yours truly. But that was the moral vision, to create this microcosm of the Justice Department and to build in structural protections to prevent against arbitrariness and abuse of saying, let's indict this person. And it's simply the act of arbitrariness and caprice of a particular actor. So we built in these various mechanisms. The fundamental separation of powers flaw, however, with the whole independent counsel apparatus was it tore asunder these traditions and cultures of the Justice Department, creating a single mission kind of office, which I think raises policy issues, and caused those who are charged with independent counsel to make sure that you have the kinds of protections that have been built in over time of the century plus of the operation of the Justice Department. It's quite an ill-conceived statute. Now, for the record, there are times when you need to bring in an outsider to conduct an investigation, and typically, and I think the politics of this got kind of confused, typically the administration under investigation brings in an individual out from the other political party, as we saw with Attorney General Reno asking the former Missouri Senator Jack Danforth, a Republican, to come in and investigate the events surrounding the tragedy, the conflagration in Waco, the Branch Davidian compound in 1993. You don't bring in your own political party to do this. I mean, go back to Watergate. Who was brought in to investigate Richard Nixon? Archibald Cox, who had served in the Kennedy administration as Solicitor General. He had served in the Truman administration in a more political role. And then who was his replacement? Leon Jaworski, a Democrat. People say, well, he wasn't much of a Democrat because it wasn't easy. But, a Democrat and confidant of Lyndon Johnson. And that's been part of our history, that you typically look to the other political party. And I think in the politics of the discussions, that very foundational historical fact got lost. Yes, sir.
Going back to your experience in Chile with the workers having the civil law in their pocket, do you think that the common law system kind of just because everything is an interpretation, you can't expect someone to walk around with the West Reporter in their pocket? between that and the fact that there's no single part of American law that you could fit in any kind of pocket, just kind of has
The Uniform Commercial Code, right? Sorry.
I haven't gotten to that yet, but I'm the first year. That just has a chilling effect on the citizens kind of using the law themselves, and that kind of just drives our society towards lawyers.
Yeah, that's a very interesting cultural point. Obviously, we're going to stay with the common law system, which we inherited. We embrace common law traditions in the constitutional framework. We embraced specific common law rights and refer specifically and expressly in the Bill of Rights to the common law, the right at common law. And that has been, I think, the happy history of England, for all of its problems over the centuries, and us, for all of our problems over the century, that the common law has served us well and I think has been a unifying force. Doesn't mean, however, that there are times when judicial powers seem to be, in contrast to civil code countries, so great that somehow enhances the sort of, or thickens the veil of ignorance behind which we, the lay audience, assuming we're talking about a general audience, labor. I think perhaps so, but I think that puts a burden, frankly, on bench and bar. One of the things that I did, or was involved in, I should say, at the D.C. Circuit, where a lot of our cases they can't be understood by the lawyers and the judges themselves. So there's very complicated cases. You really have to study to understand some of these very arcane, complex regulatory cases. You understand the framework of administrative law, you can study that in a law school. But the application can be very, very difficult and so forth. But notwithstanding that, the importance of that court has been widely noted, that they have lots of important cases, sometimes constitutional cases and so forth. So let me get to the point. I discussed this with Judge Mikva, with whom I was serving at the time. And we decided we obviously had to take it to the full court. Spotswood Robinson, now deceased, was the chief judge at the time. But the court, which included people like Ruth Ginsburg, Bob Bork, Antonin Scalia, I could keep going, Skelly Wright, wonderful, wonderful judges, said, what a great idea. Ab and Ken did C-SPAN. Did C-SPAN call-in on America and the courts. I think C-SPAN hung the moon. I listen to C-SPAN. I'm a real anybody a C-SPAN junkie? I don't watch television very much. I'm busy. But when I'm in the radio, in the car, I am typically tuning in, if I'm not trying to be inspired through some uplifting, inspirational, faith-based thing, which I need a lot of, I am in on C-SPAN radio. I love listening to this stuff. These congressional hearings, I get all worked up. I practically drive off the road. I'm in such enthusiasm over this. So it's why I live in Washington, D.C., I guess. It's a sign of a diseased mind. But, or at least a very narrow mind. So I need to do more Duke basketball. And that was great last night, by the way. But I do think, is someone tapping me on the shoulder? I think Professor Schroeder is saying your time has expired. I do think that there are mechanisms that if we really kind of set our mind to it, bench, bar, and the American Bar Association tries, and I've not given very careful thought to a business plan on this is how we do it. It was part of the reason that my dear Chief Justice, for whom I was privileged to clerk, Warren Earl Burger, a simple man from Minnesota, decided to step down from the Chief Justiceship of the United States to be the head of the bicentennial celebration. Everybody said, that is the silliest, if not dumbest thing, professional move anyone could possibly make. You're still in reasonably good health. Why would you do something like that? He felt so strongly, and so there's a lot of scoffing and mockery in it, but I knew he was sincere. He really wanted to be, put it very simply, I want there to be a national history lesson. He sensed that we needed it, and I think we still need it.
Yes,
Thank you.
That was me tapping on your shoulder. Although I'm sure we could stay here a lot longer and appreciate everything you've said so far. Although I apologize for missing the first half of it due to my own seminar. Thanks so much for coming.